Hi, my name is Lisa Cummings, and today I'm going to share with you some information about dividing federal government retirement plans. Before I talk more about dividing different types of federal government retirement plans in the event of a divorce, I'd first like to share some information with you about our firm. Our firm is Cummings and Cummings Law. You can see our website at www.cummings.law. Our firm supports individuals as well as businesses in planning all types of legal needs. Specifically, my career has focused in supporting both large organizations as well as individuals in planning their benefits, their compensation programs, as well as helping individuals plan for their future estate needs. Specifically, I'm going to focus on my area of expertise regarding retirement plans and the division of a retirement plan in the event of a divorce. Today, I want to focus on federal government retirement benefits in a divorce situation. Federal retirement programs can be a significant asset in a marriage where one of the spouses was a federal employee. In a divorce, states generally treat these federal benefits like marital property to some extent, but federal laws set very strict rules about the legal orders and how to divide these retirement benefits. These federal retirement programs require legal orders that are different from qualified domestic relations orders. Qualified domestic relations orders only apply to company-held retirement plans such as 401k plans and pension plans that are administered by companies, not the federal government. There are different types of federal retirement court orders depending upon the federal program. Federal employee retirement systems like the Civil Service Retirement System, sometimes you will see that as CSRS, and the Federal Employees Retirement System, which is an acronym of FERS. These are pensions for civilian federal workers. The Thrift Savings Plan, or TSP, is similar to a 401k plan, but it is for federal employees and military members. A third type of retirement benefit is military retirement pay. This is for service members under the Department of Defense, the Uniformed Services Former Spouses Protection Act, or USFSPA, allows state courts to treat disposable retired pay as marital property and to divide it, but it's not automatic. Courts aren't required to divide it, they're just authorized to do so. Now I would like to talk to you a little bit about those federal pensions for civilians for federal workers, the CSRS and the FERS. Federal employee retirement systems like the CSRS and the FERS are pensions for civilian federal workers. The marital share is often calculated using a fraction, and that fraction looks at the number of months of service that occurred during the marriage compared to the total years or months of service that that individual worked for the civilian federal government. And then that fraction is then applied by a benefit amount. To legally divide one of these federal pensions as a result of divorce, you need a court order acceptable for processing, or COAP, issued by the court. The Office of Personnel Management reviews and then approves that order, which is the court order acceptable for processing. If this order meets the requirements of the OPM, then they will divide the pension of the federal employee and make sure that the ex-spouse receives the portion that's set forth in the order. This order can also include survivor benefits, ensuring the ex-spouse gets payments if the retiree dies first. Without a proper COAP, the Office of Personnel Management will not divide the benefits. Also note that refunds of employee contributions can be divided similarly. A separate type of federal retirement plan is the Thrift Savings Plan. The Thrift Savings Plan, or TSP, which is similar to a 401k plan for federal employees and military members. Again, the Thrift Savings Plan is similar to a 401k plan, but instead this is for federal employees and military members. The Thrift Savings Plan can be divided in a divorce, often up to 50% of the marital portion. However, the Thrift Savings Plan requires a different type of court order. The Thrift Savings Plan requires the Retirement Benefits Court Order, or RBCO. It is not a QDRO, and it's not a COAP. It has its own requirements. So this Retirement Benefits Court Order, or RBCO, specifies the amount or the percentage, and then the Thrift Savings Plan Board processes the order, potentially transferring funds to the ex-spouse's IRA or paying it directly. Earnings on the awarded account are calculated based upon the account's performance. It is important to note the RBCO must specify whether earnings are or are not to be awarded to the alternate payee. Tax-wise, the transfer to the ex-spouse is usually tax-free only if it is rolled over properly. How these special federal orders differ from QDROs. QDROs are for private employer plans, ensuring tax-free transfers and direct payments to alternate payees, as opposed to federal benefits, which require COAPs for the pension type of federal plans, the CSRS and the FERS, which is yet different from the RBCO, which is required for the Thrift Savings Plan, and is yet different again from the Division of Military Retirement Pay, which requires yet a different order. Mistakes in drafting can lead to rejection, so specialized help is the key in ensuring your federal orders are prepared appropriately for submission to your divorce court. For more information, please feel free to visit my site at qdro.law or email me at lisa@cummings.law. Again, qdro.law or lisa@cummings.law. Thank you for joining and have a great day.